Welcome and Course Overview. Brightwell Law PLLC stands as a beacon of legal excellence and compassionate representation in Pensacola, Florida. Founded by the distinguished William A. Brightwell IV, an attorney with a rich tapestry of life experiences, ranging from the disciplined ranks of the Marine Corps to the adventurous world of skydiving, the firm embodies a unique blend of tenacity, integrity, and a deep-seated commitment to fairness. With over a decade of steadfast service, Brightwell Law has navigated hundreds of clients through the complexities of divorce, estate planning, probate, and family law, offering solutions tailored to each individual's needs and aspirations. William A. Brightwell IV, at the helm of this dynamic team, leverages his extensive background in real estate and his profound legal acumen to advocate for his clients' rights and interests. His journey through military service, corporate America, and entrepreneurial ventures has imbued him with a unique perspective on legal representation, emphasizing a holistic approach to addressing legal challenges. Whether guiding families through the intricacies of family law or assisting individuals with estate planning, William's dedication to ensuring justice and achieving optimal outcomes for his clients is unwavering. At Brightwell Law PLLC, clients find not just legal advisors, but allies committed to navigating them through their legal journeys with expertise, empathy, and exceptional service. The objectives of DIY Class 1, 12.950C, petition for dissolution of marriage with dependent or minor child (REN), and relocation, are designed to equip participants with the knowledge, skills, and confidence needed to navigate the Florida family law system, effectively, specifically focusing on self-representation in cases involving divorce, minor children, and relocation. This class aims to educate on the legal framework, provide a comprehensive overview of Florida family law as it pertains to the dissolution of marriage, emphasizing cases with dependent or minor children and the complexities surrounding relocation. Demystify Form 12.950C. Breakdown. Form 12.950C. Section by section, explaining the purpose of each part, what information is required, and the legal implications of the responses provided. Enable effective self-representation. Empower participants with the knowledge to competently fill out and file Form 12.950C on their own, ensuring they understand the process, requirements, and deadlines involved. Highlight common pitfalls and how to avoid them. Identify frequent mistakes made during the petition process and provide practical advice on how to avoid these errors to ensure a smoother legal process. Provide strategies for presenting a case. Offer guidance on how to effectively present one's case, particularly in situations involving custody, visitation, support, and relocation to ensure the best possible outcomes. Outline the process. After filing, educate participants on what to expect after the petition is filed, including the legal proceedings, hearings, and potential outcomes, preparing them for the next steps. Facilitate meaningful conversations. Prepare participants for their consultations with William A. Brightwell IV and a paralegal, ensuring they can make the most out of these discussions by knowing what questions to ask and what information to gather. Through these objectives, the course seeks to not only provide participants with the practical tools needed for filing Form 12.950C, but also to foster a deeper understanding of the legal processes involved, ultimately enhancing their ability to navigate these challenges with confidence and clarity. Overview of the Florida Family Law Form 12950C. Why this course matters. Importance of understanding legal forms in self-representation. How this course can help in filing a petition correctly and efficiently. Module 1. Understanding the basics. Introduction to Florida Family Law. Florida Family Law serves as a crucial framework for addressing and resolving legal issues that affect families within the state. This area of law encompasses a broad range of matters, including marriage and divorce, child custody and support, adoption, and domestic violence, among others. Its primary objective is to ensure the welfare and fairness for all family members, particularly when they are navigating the complexities of life-changing events. The state of Florida has specific statutes and legal principles that govern family law, making it imperative for individuals to understand these laws when facing family-related legal matters. Whether it's the dissolution of a marriage, the determination of parental responsibilities, or the protection of assets and rights within the family unit, Florida Family Law aims to provide clear guidance and equitable solutions. For those considering self-representation, especially in matters of divorce and child custody, a thorough understanding of Florida family law is essential. It not only helps in making informed decisions, but also in effectively navigating the legal system to achieve the best possible outcomes for themselves and their families. With its unique provisions, such as the no-fault divorce principle and the emphasis on the best interests of the child, Florida family law reflects a nuanced approach to resolving familial disputes, ensuring that the process is conducted with fairness, respect, and sensitivity towards the emotional and practical needs of all involved. As we delve deeper into the key principles of family law in Florida and explore the overview of dissolution of marriage procedures, it's important to approach these topics with the goal of gaining a comprehensive understanding that will empower individuals to handle their legal matters with confidence and clarity. Key principles of family law in Florida. Florida family law operates on several foundational principles designed to guide the resolution of family disputes in a manner that is equitable, respectful, and in the best interest of all parties involved, especially children. Understanding these key principles is essential for anyone navigating the family law system in Florida, whether they are going through a divorce, custody dispute, or another family law matter. One of the paramount principles in Florida family law is that decisions regarding children, including custody, visitation, and support, should prioritize the child's best interests above all else. This includes considering the child's health, safety, emotional well-being, and the capability of each parent to meet the child's needs. In divorce proceedings, Florida follows the principle of equitable distribution. This means that marital property and debts are divided fairly, though not necessarily equally, between the spouses based on a variety of factors, such as the duration of the marriage, the economic circumstances of each spouse, and contributions to the marriage, including homemaking and child rearing. Florida is a no-fault divorce state, which means that a divorce can be obtained without needing to prove fault or wrongdoing by either spouse. Instead, one must only demonstrate that the marriage is irretrievably broken, simplifying the process and often reducing conflict. unless it is deemed harmful to the child. Florida law prefers shared parental responsibility. This encourages both parents to remain active and involved in their child's life post-divorce, sharing in the decision-making processes regarding the child's upbringing. Alimony, or spousal support, is not guaranteed in Florida divorces. Decisions regarding alimony are based on the need of one spouse and the other spouse's ability to pay, considering factors like the standard of living during the marriage, the length of the marriage, and each spouse's financial resources and earning capacities. Florida law has specific requirements for a parent wishing to relocate more than 50 miles for more than 60 days with a child following a divorce. Such moves require agreement from the other parent or approval from the court, considering the impact on the child and the child's relationship with the non-relocating parent. Family law in Florida places a strong emphasis on protecting individuals from domestic violence within the family. The law provides mechanisms for obtaining restraining orders and takes allegations of domestic violence into consideration in custody and visitation decisions. These principles reflect Florida's commitment to handling family law matters with fairness, sensitivity, and a focus on the well-being of all individuals involved, especially children. Understanding these principles can provide a solid foundation for navigating the complexities of family law in Florida. The process of dissolution of marriage, commonly referred to as divorce in Florida, is designed to be as straightforward as possible, reflecting the state's commitment to reducing the emotional and financial strain on families. Understanding the procedural steps can help individuals navigate the process more effectively. Here's an overview of the key stages involved in the dissolution of marriage procedures in Florida. The divorce process begins with one spouse, the petitioner, filing a petition for dissolution of marriage in the circuit court of the county where either spouse resides. The petition must state that the marriage is irretrievably broken and outline any requests for property division, alimony, child support, and custody arrangements. Once the petition is filed, it must be formally served on the other spouse, the respondent. The respondent has 20 days to answer, acknowledging receipt of the petition and indicating any disputes to the petitioner's requests. Both parties are required to provide financial disclosures early in the process. This includes detailed information about their incomes, assets, debts, and expenses to ensure fair decisions regarding alimony, child support, and the division of marital property. In cases involving minor children, both parents may be required to complete a court-approved parenting course. The course is designed to help parents understand the impact of divorce on children and how to address their children's needs during this transition. If there are contested issues that the spouses cannot resolve on their own, the court may order mediation. Mediation is a process where a neutral third party helps the spouses negotiate an agreement on disputed matters like child custody, property division, and alimony. In the event that the spouses manage to reach an agreement through the process of mediation, or if the respondent decides not to contest the requests set out in the petition, the divorce procedure can move forward to the final hearing. This is a crucial stage where a judge takes the time to meticulously review the agreement or the petition ensuring that everything is in compliance with the law of Florida. Once satisfied, the judge may proceed to issue a final judgment, effectively dissolving the marriage. It's important to note that this final hearing is not a trial, but rather a confirmation of the agreement reached or the uncontested petition. In instances where the spouses fail to reach an agreement on significant matters such as property division, child custody, or alimony, the divorce process may need to proceed to a trial. This is a more complex and demanding phase of the divorce process. Both parties are given the opportunity to present their evidence and arguments before a judge. The judge, in turn, will make the final decisions on the contested issues. It's crucial to note that trials can be lengthy, emotionally draining, and financially taxing. Therefore, it's always advisable to seek professional legal guidance to navigate this challenging part of the process. Once the trial concludes, the court issues the final judgment of dissolution of marriage. This is the official document that signals the end of the marriage and lays out the terms of the divorce. It includes the judge's decisions on the division of assets, alimony, child support, and custodial arrangements. It's important to understand that this judgment is legally binding for both parties involved. If there are disagreements or concerns about the conditions outlined in the final judgment, the parties have the right to appeal the decision. However, it's important to note that appeals can be a complex process and may require additional legal support. This final judgment marks the end of the legal divorce process, but the emotional and practical adjustments often continue beyond this point. It's advisable to seek counseling or support groups to help navigate this new phase of life. After the issuance of the final judgment of dissolution of marriage, it's crucial to reflect on the process and understand the key considerations for the future. One of these is the residency requirement in Florida. At least one spouse must have lived in the state for a minimum of 6 months before filing for divorce. Another point to consider is the simplified dissolution process. If both parties agree on all aspects of the divorce, have no minor children, and meet certain criteria, they may qualify for this process. It's faster, less complicated, and could potentially save you time and emotional distress. Understanding the dissolution of marriage procedures in Florida is vital for those considering or undergoing a divorce. It helps in preparing for what lies ahead and facilitates a smoother transition through this challenging life event. Beyond the legalities, it's important to remember that the end of the divorce process doesn't necessarily mean the end of the emotional journey. Consider seeking counseling or joining support groups to help navigate this new phase of life. It's okay to seek help and take time to heal. Remember, you're not alone in this journey, and there are resources available to help you get through this challenging time. Navigating the complexities of family law in Florida can be a daunting task, especially when it involves significant life changes, such as a dissolution of marriage, accompanied by concerns of dependent or minor children and relocation. Form 12-950 IC, Petition for Dissolution of Marriage with Dependent or Minor Child, REN, and Relocation, serves as a critical document in these proceedings, designed to streamline the legal process for families undergoing these transitions. In this segment, Form 12.950C, Explained, we aim to demystify this essential legal form, providing a clear, step-by-step guide that illuminates its purpose, the specific sections it comprises, and the types of information required from the petitioner. This overview is intended to equip individuals with the knowledge necessary to fill out the form accurately and confidently, ensuring that they can articulate their circumstances, requests, and plans regarding their children and any intended relocation effectively within the legal framework of Florida family law. Understanding. Form 12.9950 is not just about filling out paperwork. It's about grasping the legal implications of your requests and how they align with Florida's commitment to protecting the best interests of children involved in family law cases. Our explanation aims to make this form more accessible, helping to reduce the potential for errors and misunderstandings in a process that significantly impacts the lives of all parties involved. The purpose of Form 12.950C, Petition for Dissolution of Marriage with Dependent or Minor Child, REN, and Relocation, is multifaceted, serving as a crucial instrument in the legal orchestration of family dynamics during a period of significant transition. This form is specifically designed to address the complexities that arise when a dissolution of marriage involves dependent or minor children and one of the parents intends to relocate. Here are the primary objectives of Form 12.950C. 1. Legal documentation of divorce with children. It formally initiates the process of divorce in the Florida court system, specifically tailored to cases where there are dependent or minor children involved. It ensures that the divorce proceedings consider the children's needs, living arrangements, and welfare. 1. Framework for child custody and visitation. The form provides a structured approach to outlining proposed arrangements for child custody and visitation. It aims to ensure that such arrangements prioritize the best interests of the children, facilitating a stable and nurturing environment post-divorce. 1. Basis for child support calculations, by including detailed information about each parent's financial situation and the needs of the children. Form 12.908 Side 50 GLYC lays the groundwork for calculating child support. This ensures a fair and adequate provision for the children's financial needs. 1. Mechanism for parental relocation proposals. Crucially, the form addresses situations where a parent wishes to relocate with the child, REN, at a significant distance from the other parent. It provides a legal avenue to propose and justify such relocation, considering the potential impact on the child, REN's relationship with both parents. 1. Legal compliance and clarity. Filling out and submitting Form 12.950C ensures compliance with Florida's legal requirements for divorce involving children and relocation. It helps prevent legal oversights and clarifies the petitioner's intentions and requests to the court, facilitating a smoother legal process. 1. Foundation for negotiation and mediation. In contested cases, the information provided in Form 12.950C can serve as a basis for negotiations or mediation between the spouses. It helps identify areas of agreement and contention, guiding the discussions towards a resolution that serves the best interests of the children involved. In essence, Form 12.950C is designed to navigate the delicate balance between facilitating a legal dissolution of marriage, ensuring the well-being and stability of any dependent or minor children, and addressing the logistical and emotional challenges of parental relocation. Its comprehensive nature allows for a detailed examination of the family's circumstances, aiming for outcomes that respect the rights and needs of all parties involved. Form 12.950C. Petition for dissolution of marriage with dependent or minor child, REN, and relocation is meticulously structured to gather comprehensive information necessary for the court to make informed decisions regarding divorce, child custody, support, and parental relocation. This overview will dissect the form into its constituent sections, highlighting the types of information required from petitioners to ensure a thorough and clear presentation of their case. Marital details, dates of marriage and separation, marriage certificate details, and grounds for the petition for dissolution. Children details, names, dates of birth, and current residences of all dependent or minor children involved in the case. Residency, confirmation that at least one spouse meets Florida's residency requirement for filing a divorce. Grounds for divorce, assertion that the marriage is irretrievably broken, meeting Florida's no-fault divorce criteria. Parental responsibility, proposals for shared or sole parental responsibility, considering the child's best interests. Time-sharing schedule, detailed proposals for how the parents will share time with the children, including daily living, holidays, and vacations. Financial information, income details of both parents to calculate child support in accordance with Florida's guidelines. Childcare and healthcare, information on childcare expenses, health insurance, and medical expenses for the children. Marital and non-marital assets and liabilities, listing and proposals for the division of marital assets and debts, including real estate, personal property, and financial accounts. Spousal support, requests for alimony, if applicable, including type, amount, and duration, based on the needs of the requesting spouse and the other spouse's ability to pay. Relocation proposal, detailed reasons for the proposed relocation, new address, and how the move affects the time-sharing plan and the child's relationship with the non-relocating parent. Notice and consent, information on notice given to the other parent and whether consent has been obtained. Additional relief. Any other relief the petitioner is seeking from the court, which could include name changes or specific orders related to the dissolution process. Oath and signature. The petitioner must swear to the truthfulness of the information provided and sign the form in the presence of a notary or deputy clerk. By providing detailed information across these sections, Form 12.950C allows petitioners to present a comprehensive picture of their marital situation, the needs and best interests of their children, and the logistics of proposed relocation. It's designed to ensure that the court has all necessary data to make decisions that reflect fairness, legal compliance, and the well-being of children involved in divorce and relocation cases. Section-by-section guide, detailed walkthrough of each section of Form 12.950C, explanation of legal terms and concepts found in the form, common mistakes to avoid typical errors and how to prevent them, importance of accuracy and completeness, legal considerations, custody, visitation, and support considerations, legal requirements and implications of relocation, completing the relevant sections, how to accurately fill out sections related to children and relocation, tips for presenting your situation clearly and effectively, gathering and preparing, supporting documents, list of necessary documents to accompany your petition, tips for organizing and presenting your documents, filing your petition, how and where to file. Form 12.950C, understanding filing fees and waivers. What to expect. The process after your petition is filed. Timeline and key milestones. Preparing for your hearing. Tips for self-representation in court. How to prepare your case and present evidence. Maximizing your consultation. How to prepare for your 30-minute conversations with Attorney Brightwell and a paralegal. Questions to ask and information to gather. Recap and next step summary of key points covered in the course. Encouragement to review materials and practice filling out the form. Additional resources. Further reading and resources for deepening understanding. Information on other DIY classes and services offered by Brightwell Law, PLLC. Call to action, encouragement to schedule a consultation for personalized advice and representation options.